If you've used an Android phone at any time in the past 9 years, you could be entitled to money, and there's a very good chance you haven't heard about it yet. A new nationwide class action settlement could result in payments to as many as 100 million Android users across the United States. Google has agreed to pay $135 million to resolve allegations that it collected data from Android phones without proper user consent. The company is not admitting fault, but it has agreed to settle the lawsuit known as Taylor versus Google LLC. The official settlement website is now live, and eligible users can already take steps to make sure they receive their payment. This case stems from long-running claims that Google harvested data from Android devices even when users were not actively using their phones. According to reports, the issue involved passive data transfers and the use of cellular data connections in ways many users may not have fully understood. While the legal battle has been ongoing for years, this settlement represents a significant development. It's important to understand that this is not the only lawsuit over this issue. Last year, a separate case specific to California residents was settled for $314 million. That case applied only to people in California. The current $135 million settlement applies more broadly to Android users across the rest of the United States. If you are a California resident, you should look into the California-specific settlement to determine whether that one applies to you instead. If you live outside California, this nationwide settlement is likely the relevant one. Now, let's talk about who qualifies. There are 4 basic requirements to be included in this settlement. First, you must be a living individual residing in the United States. That may sound obvious, but class action settlements often spell things out very specifically. Second, you must have used an Android mobile device with a cellular data plan. Technically, someone could own an Android device without cellular service, but this case concerns phones that were connected to cellular networks. Third, you must have used that device at some point between November 12, 2017, and the date the settlement receives final court approval. That time frame stretches back nearly 9 years, meaning millions upon millions of people could potentially qualify. Fourth, you cannot be a class member in the separate California case if that case applies to you. The final approval hearing for this settlement is scheduled for June 23rd. At that hearing, the court will consider objections and evaluate whether the proposed $135 million settlement is fair, reasonable, and adequate. The judge has the authority to approve or reject the agreement. If there are objections from class members, those will be heard as well. If you want to object to the settlement or exclude yourself from it, there are deadlines. Written objections must be submitted by May 29th. Instructions for how to object, how to opt out, or how to request permission to speak at the June 23rd hearing are available on the official settlement website. In the meantime, eligible individuals can visit the website and select their preferred payment method. Even though the settlement has not yet received final approval, class members are being encouraged to choose how they would like to receive their money. If you do nothing, you will still technically be included in the settlement and issued a payment. However, you may not actually receive it if you do not select a payment method. That means taking a few minutes to visit the site could make the difference between receiving compensation and missing out. Now, how much money are we talking about? The maximum possible payment per class member is capped at $100. However, that does not mean everyone will receive $100. The actual payout depends on several factors, including how many valid claims are processed and how much money remains after certain deductions. Before payments are distributed, funds will be used to cover administrative costs, taxes, and attorney fees. Once those expenses are paid, the remaining money will be divided equally among eligible class members. If there are funds left over after initial payments are made, and it is economically feasible to send additional money, the settlement administrator may issue supplemental payments to members who successfully received their first payment. However, if the leftover amount is so small that redistributing it would cost more than it's worth, for example, if it would only amount to a few cents per person, then the remaining funds will not be redistributed. Instead, that money will be directed to an organization approved by the court. Often in cases like this, such organizations are related to consumer protection, digital privacy, or public interest causes, though the final decision rests with the court. It's also important to note that payments will not be issued immediately. They will only be distributed after the court grants final approval and after any appeals are resolved. Appeals can take time. So even if the settlement is approved on June 23rd, the actual checks or electronic payments may not arrive until months later. Beyond the money, this settlement also includes changes to Google's disclosures and policies. As part of the agreement, Google will update its Google Play Terms of Service to clarify certain data practices. Specifically, the updated terms will explain that some data transfers may occur passively, even when a user is not actively engaging with their Android device. In addition, the updated disclosures will inform users that cellular data may be used when the device is not connected to Wi-Fi. In some situations, this type of data activity cannot be completely disabled. During device setup, users will be asked to consent to these data practices. The goal, at least in theory, is to increase transparency so users better understand what is happening behind the scenes on their devices. Another key change involves the Allow Background Data Usage setting. Under the settlement terms, when this option is toggled off, Google has agreed to fully stop collecting data under those conditions. That represents a clearer commitment than what plaintiffs argued existed before the lawsuit. Stepping back, this case highlights a much larger issue that goes far beyond one company or one settlement. Modern smartphones are incredibly powerful devices. They track location data, search history, app usage, browsing patterns, and countless other data points. Your phone likely knows where you were yesterday, which routes you took, which stores you visited, and how long you stayed. It records searches, preferences, and interactions in ways most people rarely think about. Some people respond to privacy concerns by saying, "Who would care about my data? I'm not that interesting." But that perspective misses the point. Individually, one person's data may not seem significant. Collectively, millions or billions of data points become extremely valuable. Companies operate massive data centers, enormous facilities filled with servers capable of storing and analyzing almost unimaginable amounts of information. With that processing power, it becomes possible to identify patterns, trends, and behaviors on a massive scale. For example, companies can determine how many people pass through a particular intersection every weekday, how long they stay in a given area, or what types of stores they visit afterward. Data can reveal commuting patterns, shopping habits, and consumer interests with remarkable precision. Many people have experienced a common example of this phenomenon. You search for a product on one platform, perhaps using a search engine, and shortly afterward, advertisements for that exact product begin appearing on entirely different platforms, such as social media sites. You didn't search for it there, you didn't mention it there, yet somehow the ads follow you. This cross-platform targeting is made possible by extensive data collection, tracking technologies, and sophisticated advertising systems. While such practices are often disclosed in privacy policies and terms of service agreements, most users do not read those documents in detail. Lawsuits like this one argue that disclosures were not sufficiently clear or that users did not meaningfully consent to certain types of data collection. If you think back 20 years, the landscape was very different. At that time, computer storage was expensive, and processing power was limited compared to today's standards. People questioned whether it would even be feasible to store detailed information about everyone's daily movements and activities. Where would all that data go? How could it possibly be analyzed? Today, those concerns have largely disappeared. Massive server farms, sometimes referred to as data centers, store and process staggering quantities of information. Advances in cloud computing, artificial intelligence, and machine learning allow companies to sift through that data quickly and efficiently. What once seemed impractical is now routine. Of course, marketing is one of the primary uses of such data. Targeted advertising is a multi-billion-dollar industry built on the ability to understand consumer behavior at a granular level. By analyzing patterns, companies can tailor ads to individuals with impressive accuracy. But marketing is not the only potential use of large-scale data collection. Questions often arise about who else might gain access to stored information and under what circumstances. While privacy policies and legal safeguards exist, the sheer volume of data being collected naturally raises concerns for many people. This settlement does not resolve every question about digital privacy. It does not end data collection practices. What it does is address specific allegations about how Android devices handled data transfers and how those practices were disclosed to users during the relevant period beginning November 12, 2017. If you used an Android phone with a cellular data plan anytime during that period, it may be worthwhile to check whether you qualify for compensation. The process involves visiting the official settlement website for Taylor vs. Google LLC, reviewing the eligibility requirements, and selecting your preferred payment method. Remember the key dates. Objections must be submitted by May 29th. The final approval hearing is scheduled for June 23rd, though dates can sometimes change, so it's wise to check the website for updates. Payments will be issued only after final approval and the resolution of any appeals. While the maximum individual payout is capped at $100, the exact amount will depend on how many eligible users participate and how much remains after costs are deducted. Even if the payment ends up being less than the maximum, it represents acknowledgement that the legal system scrutinized these practices and required changes and compensation. At a minimum, cases like this encourage greater transparency. They push companies to clarify their terms of service, explain how data is used, and provide users with clearer choices about settings such as background data usage. Whether you view this settlement as a major victory for consumer privacy or simply a modest financial recovery, it serves as another reminder of how much information modern devices collect and how valuable that information has become. If you think you qualify, take a few minutes to look into it. Review the details, confirm your eligibility, and choose your payment method before the court makes its final decision. With potentially up to 100 million people eligible, there's a strong possibility that many Android users will want to check whether they're included. The digital world runs on data. This case shows that when questions arise about how that data is collected and disclosed, the legal system can step in, sometimes resulting in substantial settlements and policy changes.